And we are right at 6:30, so let's get started. Want to welcome you all to our Dollars for Scholars Connect session. We have Brianna Moody with us today, and she advises tax-exempt organizations on their governance and operation and tax compliance. But she also has a vast um, extensive experience in working with individuals on their estate planning and tax planning, and so we're just so delighted to have her with us this evening. What we'll ask you all to do is, if you have questions, please put those in the chat. Just write those questions in the chat as we go along. And Brianna was just generous enough with her time that she has planned to answer all of your questions at the end. So we've saved adequate amounts of time at the end of her presentation to answer your questions. So please just put those questions in the chat. And so without further ado, I will turn it over to you, Brianna.
Thank you, Nicole. Good evening, everyone. As Nicole mentioned, I'm an attorney with Faegre Drinker, and we are very pleased to work with Scholarship America. And so it's very much my pleasure to be with you all this evening. I know it's late for particularly our East Coast attendees, and so we'll try to be very respectful of your time today, especially as I'm sure many people are getting ready for the holiday weekend for Labor Day. So today we're going to cover a number of topics, kind of a high-level overview of some estate planning concepts, plan giving concepts that we anticipate you will run into as you're working with donors and prospective donors as part of the important work that you do supporting your Dollars for Scholars chapters. So as Nicole mentioned, we'll be collecting questions as we go in the chat, and I will do my best to cover all of them today. We really want this session to be as helpful to each of you as possible, so that we're being valuable of your precious time. So with that, our agenda today, we're going to start kind of just talking about some basic estate planning concepts. I'm going to go pretty general. I imagine there's different levels of expertise in the room. And so just kind of talking a little bit about what comprises an estate plan and what might donors be referring to as they're talking about their own estate plan. We're going to talk about some charitable giving vehicles outside of those estate planning documents. We're going to get into plan giving, both kind of what it is when someone's talking about a planned gift, and then also what some common types of planned gifts are that donors might be interested in making. We're going to hit on restricted gifts and endowments and kind of what those are and what impact that has both on donors and also on your chapters in terms of administering those gifts. And then again, we're just going to try to leave time for questions so that you can bring up things that you're experiencing in your work with your chapter. So when we're talking about an estate plan, we're talking about the proactive steps that someone might be taking to ensure that the people and organizations that they choose are receiving the things that they own at the time that they pass away. So a typical estate plan would be comprised of 3 or 4 main documents. So the most common is going to be the will, and the will kind of either serve one of 2 functions. It will either be discussing all of the things that happen when that person passes away. So where all of their assets go, who's in charge of administering their estate, or in a number of jurisdictions where a revocable or living trust is popular, the will might just say, when I pass away, give everything to my trust. And the document that really does all the heavy lifting is going to be a revocable trust or a living trust. So we'll talk about that a little bit later. An estate plan is also going to include 2 documents that really don't, or are actually in effect while the person is still living. And those are a healthcare directive, which in some states are called a healthcare power of attorney. And what that document does is it will appoint someone to be a healthcare agent or proxy that gives another individual the right to make healthcare decisions on that person's behalf. And it also can include specific guidelines and wishes around what type of end of life care the person wishes to have, what they would like to have happen to their remains when they pass away, burial, funeral wishes, all sorts of things can be encapsulated in that document. And then there's also a financial power of attorney, which is like a healthcare directive, only applicable when the person is still living. In most cases, it applies when the person's incapacitated. So if someone were to get into a car accident and be unable to make decisions, but that really dictates who is able to make financial decisions on someone's behalf. And so those two documents really apply while someone's alive. And then once they pass, we're really looking at the will and the revocable or living trust. And so those will be some of the documents that we'll be talking about in more detail today as part of this plan giving concept. And then estate planning also includes planning with beneficiary designations on retirement accounts and life insurance policies. And so those are documents that often don't require the use of an attorney to prepare those documents, but what they do is dictate who receives someone's life insurance benefits or retirement account balances when that individual passes away. I think where I cut out was without a revocable trust. So, and then it also allows you to designate guardians for minors. It reduces administrative costs. It provides certainty for your loved ones about what you actually wanted to happen. Lots of benefits to having a will in place. And then in terms of a revocable trust, this is often referred to as a will substitute because it functions in the same way as a will. The benefit to it is that you create and fund it during your lifetime. So if I'm creating the Brianna Moody Trust, I transfer my assets to it during my lifetime. It's completely disregarded for income tax purposes. I can change it anytime I want to during my lifetime. But what it does is it avoids what's called probate, which is a state court process to oversee a will, which means that if something happens to me, someone can step into my shoes and administer my estate more quickly. The will does not get filed with the court, so there's more privacy. And these are also, I understand we have some participants from Washington or Arizona, other states where they're community property states. So joint revocable trusts are particularly common in those jurisdictions just for planning purposes. So it often takes a little bit more planning on the front end to get all of your assets transferred and make sure that the plan is going to function the way you want to, but then you avoid that court process on the back end. So it is popular for a lot of individuals as they're going through the estate planning process. So as I mentioned, some of the reasons why you would do it is that probate avoidance. There's additional creditor protection that can be gained with a revocable trust. Because you're not filing it with courts, you have some more anonymity. I think I have owned outside of Minnesota, but we've got lots of jurisdictions here. But if you own, I'm in Minnesota, but if you own property in multiple states, so let's say you're like many of my neighbors, you have a place in Minnesota that you spend the summer in, and then when it gets too cold, you go down to Arizona. If you're owning real estate in multiple jurisdictions and you pass away with a will, you have to go through probate, that court process, in every state in which you own real estate. So a revocable trust allows you to avoid not just one court process in that instance, but multiple. So then it becomes more attractive. And as I mentioned, with the ability to skip the court process and get someone in right away, it also helps with incapacity planning in the sense that with a power of attorney, even though these are very widely used, well-respected documents, a lot of medical institutions actually have a lot of hesitancy allowing someone to act on someone else's behalf because they're worried about someone doing something that they shouldn't, right? So taking advantage of someone or otherwise acting in an inappropriate. So I imagine the group is relatively familiar with retirement accounts, there's multiple kinds. So 401ks, 403bs are generally referred to as traditional accounts in the sense that you're able to put pre-tax dollars into the retirement account, let that account accumulate and grow, and then you are able to then take distributions out of that account at a later date, at which point they are subject to income tax. And then there are also Roth retirement accounts that allow you to take post-tax dollars, put them into a retirement account that then can grow so that when you're taking those dollars out later in life, they're not subject to income tax. So as we'll discuss a bit later, because the traditional accounts are subject to income tax upon withdrawal, they're great assets for donors to give to charity. And that became even more true after the passing of the Secure Act. So the Secure Act was passed, and so before the Secure Act was passed, there were a number of options for individuals to stretch out the tax impact on their retirement account. So in certain instances, spouses would be able to stretch the benefit for their lifetime. In certain instances, non-spouse beneficiaries were also able to take the assets out over life expectancy, which meant that if the beneficiary really didn't need to take them out in a faster time period, they could really delay and defer the tax hit that would be applied to the account. After the Secure Act, that largely went away, and most beneficiaries only have a 10-year window to take out life insurance. Most commonly, people will have life insurance that's term life insurance, is not necessarily permanent or whole life insurance. If they do, it's often used to provide liquidity. Perhaps someone has a business or other illiquid assets, and so they want to have some liquidity either for estate taxes, administrative costs. For individuals that may have a child with a disability, life insurance is a great asset to use to fund a trust for that disabled child, or perhaps a different family member that has. And with life insurance proceeds, they are not subject to income tax in the same way as a traditional retirement account. So there's that benefit to them. So that's where we're going to kind of end with the estate planning. So if you have more questions on that, please do leave those in the chat. So why we're all here, right, is to talk about individuals who are interested in gifting or perhaps leaving assets to charity. The primary reasons why they would do so would be, of course, a commitment to the mission of the organization. Your donors are going to be passionate about education and supporting scholarships for children. So this is the main driver that's going to bring them to the table. Generally, people like to save some taxes if they can, while supporting their favorite organizations. And so part of what we want to talk about is ways that they can do giving tax efficiently, and to create a legacy. I think a lot of particularly with scholarships, people get excited about the idea to have a legacy that helps provide education for generations in the future. And so that will be a big driver for the donors that you're speaking with. When we're talking about, I think people are generally familiar with annual giving, sometimes what we will call checkbook giving, where a donor is going to be, just writing checks out of their personal accounts to do gifts. There are a couple other charitable giving vehicles that we wanted to discuss. The first is a donor advised fund, and these are relatively new in the philanthropic world. They've been around for a couple decades, but what a donor advised fund is it is an account that is held at a charitable institution. So it's an account at a nonprofit organization that is tax exempt. So the most common examples would be community foundations. Schwab Charitable is a tax exempt organization that can hold these. Fidelity Charitable. So a donor would receive an immediate tax benefit or deduction. So it applies for the income tax deduction immediately for their contribution. So if I open up a donor advised fund at the Minneapolis Foundation, which is a community foundation here in town, I put $30,000 into it, I get a $30,000 income tax deduction, subject to the AGI limits and all of those things. But while it's in that account, there's no tax on any investment income, and I don't have to make any filing requirements as a donor. So I don't have to do an income tax return. I don't have to do other compliance filings. I can just have that money in that account. And you may have seen things in the news where these accounts are getting more coverage because there's some concern that individuals are just parking money for a long time and not actually distributing it to charity. But for the time now, they're very widely used, very well accepted funds that we may see some rules that will treat them more like a private foundation, which I'll discuss in the future. But they're very beneficial for donors who may not have a lot of cash, but they may have appreciated securities. And they could have $50,000 worth of appreciated securities. They don't want to maybe give all of that money to one organization, but they don't want to have to liquidate the security, pay the tax, and then contribute the cash to charity. So what they can do is contribute the stock that's appreciated to the donor advised fund, liquidate it within that fund. There's no tax then on the liquidation. They get a fair market value deduction, and then they have that full $50,000 that then they can distribute out to their favorite charities without having to pay that capital gain. So very popular planning strategy that we're seeing more and more. Historically, if someone wanted to be able to do something like pay that or use securities or kind of lump fund into an account that they want to then be able to distribute out to other organizations, they would have had to form a private foundation. And a private foundation is a separate legal entity that applies for tax exempt status on its own. They're generally funded by an individual, a family, or a corporation, which is why they're not a public charity, because they're not getting donations from a broad enough category of people to be considered a public charity, but they still do apply and get their own tax exempt status. So again, if a donor contributes to a private foundation, they still get an immediate tax deduction for their contributions. The AGI limits are lower than for public charities. So donor advised funds have the benefit of, so Schwab, Fidelity, the community foundations, those are all public charities. So when you're making a contribution to a donor advised fund, you get the benefit of those higher limits. Private foundations have lower limits. There is a small tax on investment income that's generated within a private foundation, and there are numerous annual filings that private foundations have to do. So they may have to register with the Attorney General. They're going to have to file income tax returns. On their income tax return, they have to disclose the distribution or the contributions that they made from the private foundation. So if I don't want, and these are also public, their income tax returns are public. So if I have a private foundation, anyone can go online, find out how much money is in my private foundation, who I make contributions to, who my trustees are, if they're paid a salary. Whereas with the donor advised fund, you get a lot of anonymity and you don't have the administrative burden of a private foundation. So they really are, for most individuals, a more attractive option of still being able to kind of take advantage of those items without the burden of a private foundation. So those are kind of the two main charitable giving vehicles outside of an individual giving their own assets that you may encounter in your work with the chapters. So when we're talking about planned giving, what we're really talking about is a charitable gift that requires some assistance of a professional advisor. It's not an annual gift of cash. What we're talking about is a transfer of wealth in most instances rather than income. So We'll get into some of the most common types. So a bequest is the most common form of a planned gift by far. What it is it's a provision that's included in the donor's will or in their revocable trust. It would say something like, I give $10,000 to Scholarship America, and that's, upon my death. It can be of any amount. It can be a percentage of their assets. You can say, 10% of what I own goes to my Dollars for Scholars chapter, and then the other 90% is split among my children. So that would be the most common. A lot of individuals also include charities as what we would call a contingent beneficiary. So if something were to happen to their immediate family, they would have a provision that says, if my family doesn't survive me, then all of my assets go to charity. And so that is referred to as a bequest. With retirement accounts and life insurance, the most common way that individuals will include a charity is by naming them on the beneficiary designation. I'll talk in just a second. There's another use of retirement assets, but then the easy thing about the beneficiary designation is that it generally doesn't require any involvement by an attorney or other advisor. So if your retirement account is at Fidelity, Fidelity will give you the form that tells you how to fill out, do you want them to get a percentage, or how much of your retirement account you want to go to the specific charities. They may ask for your taxpayer identification number, your EIN, so that they can list that on the form so that it goes to the right place. But it's an easy way for them to be able to ensure that the chapter gets a portion of their assets. When donors are looking, if they have both retirement accounts and permanent life insurance, it's always going to be more tax advantageous for them to use the retirement account for charity and the life insurance for their family if they're trying to kind of split up assets between those two categories. Because the retirement account, let's say there's 100,000 in it, with federal and state taxes, the child might get 60,000 of that 100,000, but the charity would get the full 100,000 because they're a tax exempt organization, so they don't have to pay the income tax on a traditional retirement account. They get 100% of those dollars. Life insurance, not subject to income tax in the same way. So if they've got $100,000 of life insurance, $100,000 retirement account, they want to split it, that would be the way that we would recommend that they do that. With qualified charitable distributions, so this is something where if a donor is already, so if they have a traditional retirement account, they are already taking required minimum distribution, so they've hit 70 and a half or older, age 70 and a half or older. What they can do is, instead of having their minimum required distribution go to them and hit their income tax return and pay income tax on that, what they can do is instead make a qualified charitable distribution. It can be up to $100,000, depending on, so it could be their entire required minimum distribution, or if their required minimum distribution is over $100,000, it has to be less than that. That's the maximum. And it would have to go to a qualified charity, which your chapters would be. So it can't go to a private foundation, it can't go to their donor advised fund, but it could go to your chapter. And the benefit to that is that rather than the donor having to pay income or reduce their minimum distribution by the amount of income tax, they can instead just direct it to the charity right away, so that that amount isn't reduced by their income taxes. So that's a really nice benefit for individuals who are at that age of 70 and a half and older, are taking their required minimum distributions and have charitable intent. And it is something that's nice for organizations like yours, where they don't have the option of directing it to the donor advised fund first. So it's a way for you to kind of encourage them to direct that directly to your chapter to charity in order to be a qualified charity. The other main category of planned gifts that we're going to talk about today is real estate. And so oftentimes a donor's most valuable asset will be real estate. And so it could be their primary residence, it could be a farm, a cabin, and you know, any real estate. And they may, we come across this a lot in Lake Country with cabins, and also with farms or any real estate. They've determined that their children do not want the home that they have. And so they want to keep that cabin or the farm or the residence for the rest of their lifetime. They want to stay there and continue to be able to use it, but they know that their children aren't interested in it, and they like the idea of using the appreciation on that as a way to benefit charity. And so what the donor can do is gift a remainder interest, which means that they retain a lifetime interest. So they get to continue to use sorry, everyone, I'm not sure what's happening. Thank you for your patience and putting up with this. Okay, so again, really nice way for someone who does not want to have to move, but wants to be able to benefit a charity, to be able to use this, what is, again, usually their most valuable asset, to benefit an organization that they care about. Okay, so the next thing we wanted to talk about a little bit is the difference between unrestricted gifts and restricted gifts. So a restricted gift.
And one of the things that I know that she's going to share with you is the importance of working with your donors to limit the number of restrictions on their gifts. I know you all have heard the story of, you know, the donor who wants to provide a scholarship to the blue-eyed, red hair student who's going to go to culinary school, right? And so it, you know, that will limit the number of students that you can provide scholarships to. So as broad as your donor can be in terms of their eligibility requirements for their scholarships, the better off you are, because the more students that you will have that will be eligible for your scholarships. So that's just something to keep in mind. But I am sure that she will come back.
I'm back. Oh, okay. So, and well, I mean, Nicole, make sure that I get that question, but yeah, so restricted gifts. So when we're talking about, kind of practically speaking, when you're working with donors, oftentimes they're going to come into the room likely thinking that they want or need to have restrictions on the gift. And I think for the flexibility of your chapters, so, you know, a particular scholarship fund, that can be easy if they're trying to get really specific with certain scholarships or restrictions on who can receive a scholarship. Obviously, it makes it much harder for you to find the right student or for the organization to use those funds. Unrestricted gifts are definitely the best from the organizational standpoint. And so what we've seen kind of in the philanthropic space is really engaging in conversations with donors. And what Nicole and I talked a little bit about is that you, as volunteers who are deeply engaged in the work of your chapter, are going to be able and armed to discuss the scholarships that you have, the needs in the schools in your area, how funds are deployed, and ideally help build trust with the donor so that they feel comfortable just saying, I support your chapter, and I'm happy to just write this check to support the chapter, and really give you more flexibility to keep the lights on if you need to, and also support all of the initiatives that you're supporting. So sometimes it can be a little it's really just about listening and kind of engaging with them to help them understand that regardless of what, if they give an unrestricted or not, the unrestricted gift will still allow you to do all of the wonderful work that the chapters are doing in supporting students, but with more flexibility. And then similarly, a restricted gift can also be used to create an endowment. And what an endowment is a fund that's held by a charitable organization. And basically the idea is if I give, $500,000 and I say I want to create an endowed scholarship, what I'm trying to do is give enough money that as that fund, that those assets then get invested, only say roughly 5% of the fund can get paid out. And then the rest of the assets are left in that invested account, and they're subject to numerous restrictions by state law and by the agreement that the donor signs with the organization. But the idea is that by only paying out 5%, I can have that fund continue in perpetuity, right? So this fund will continue to grow, hopefully at more than 5%, so that we're not depleting the assets. We're not having to liquidate securities or things like that in order to pay out the scholarship, but it really is allowed to grow over time, or at least sustain itself over time, right? And so these are going to be the most restricted, because they, as I mentioned, are subject by state laws on how they can be invested, how they can be managed, what terms have to be involved, what needs to happen if there's ever a change in circumstances and you need to change the purpose for these funds. And so really, if donors are coming to you and they're saying, I've got $10,000, I want to do an endowed scholarship, that might not be the right fit based on kind of the payout amount that you would be able to get for that value of a donation, right? Because if they are doing a $10,000 endowment fund, that can only pay out $500 a year. And so maybe that works for the educational applications that you would be looking at for that, but often the more restricted, and once we get into endowments, we really are hoping to work with more money, or even maybe just contribute to an existing endowment or an existing scholarship fund, so that you're able to really meet the needs of those scholarships. So with that was where we were planning to end off. So I'm going to stop sharing my screen and hope I do not lose any more connectivity. And I am very much looking forward to your questions.
Well, and you have quite a few of them. So let me start us off. Okay. Let's see here. Are there any forms that you recommend? Are there forms that you recommend? Phyllis, do you perhaps want to come off mute and specify the forms you're speaking of?
As we would be talking to donors, I didn't know if there was some paper information that we could give them, or other than just tell them they'll need to go to their lawyer to put it in their will, for instance.
Yeah.
Or examples of what can be given.
Sure.
Is there some sort of information we can leave people?
So Nicole, I don't know if there's anything that Scholarship America has for the chapters. So in general, you want to be clear when you're working with donors that you're not able to provide legal or tax advice, right? You don't want to be in a situation where a donor is saying, Brianna promised me in this conversation that this qualifies as a tax deductible gift, or this was the right way to put it in my will. And so I think, but we can certainly look at whether it would be helpful to put together a kind of a plan giving overview that chapters could use. If you're speaking to, I know there's a lot of software out there currently, and in when I in my background, I was in private practice, and then I went in-house to wealth management firms, and saw a lot of individuals who would use LegalZoom or other that kind of software to try to put their will together. And in most instances, what I saw didn't work legally. It would actually probably have caused a lot of litigation and been much more expensive than working with an attorney. And so I get very wary when people have told me that their estate plan is in place, and they didn't work with an attorney. So I think really encouraging donors, particularly if they're looking at trying to leave a bequest, or things that are more complicated than a beneficiary designation, certainly encourage them to work with an attorney. And then when it comes to if they're trying to leave a gift to the chapter with their life insurance or their retirement account beneficiary designation, certainly you can provide them with, they may ask you for the legal name of the chapter to make sure that they are getting it to the right place. They may ask for your federal tax ID number and things like that. And so certainly feel free to give them those pieces of information. But for plan gifts, the recommendation you'd always want to be encouraging them to seek out legal counsel so that they ensure that everything is going to be tied up properly.
Mm-hmm. And we do have a document in Affiliate Resources. It's an agreement to establish an endowed scholarship fund. It's a template, and you and your donor can use that in consultation with their legal counsel to help establish an endowed scholarship fund. So we do have that resource. And then another question that came in, how do you find out what rules are in your state for if you die without a will?
So each state has a set of statutes. Generally, it's called the probate code, that will have the rules around what happens if you die without a will. And again, the legal term for dying without a will is called intestacy. But in most instances, what happens is if the individual is married, the assets go to their spouse. If the individual is not married, but they have children, it's divided equally among the children. If the children are minors, it would go into what's called a custodial account until the minor is 18, and then the minor gets whatever the assets are. Which for some of my clients, when I was an estate planner, was terrifying to them that an 18-year-old would get a lump sum amount. And so part of the benefit of a will or a revocable trust is that you can do alternative planning for minors. If the individual does not have a spouse and does not have children, it would go to their parents. If they don't have parents, it goes down the tree from there. So to their siblings. If they don't have siblings, to their nieces and nephews, and then it just kind of continues to more and more remote, and more and more remote relatives. So estate planners will know what a first cousin, second removed type thing is, because sometimes those family tree pieces are important. But each state has those statutes. Generally, they're accessible online if you wanted to look and see.
Until she joins us again, just one other note I'd like to share with you all is that we also, you can request from us to whom letter that we can provide to you to share with your donors that just shares your relationship with Scholarship America. So for many of our chapters that are grassroots or community chapters, and not affiliate providers, Scholarship America is the 501c3 holder. for your chapter. So it's good for you to provide that information to your donors so they understand your relationship with Scholarship America, and that you are a 501c3 tax exempt organization because of your relationship as an affiliate of Scholarship America. So we can provide that documentation for you. Deb, did you want to add anything to that? Deb Fickner?
Basically, it's a a letter in good standing. So it just tells your donors that you are in good standing with Scholarship America and the relationship between Scholarship America and your chapter. So
Let's see, another question here for you is, I would like to purchase estate planning brochures that are mostly pre-written, but that I could add my organization logo and potentially a little content to. Do you happen to know of a good vendor for materials like that? We are sorry for the technical difficulties. If we do not get through all the questions, I will submit them to Brianna and have her answer them, and I can send them to you at a later time when we send out the slides. So
Nicole, we'll see how this lasts. I can try to call in too from my phone, but I don't know of I think the trouble with having a vendor like that, I mean, you could engage a local attorney to do it, but the state rules can be very different. And I think, Nicole, perhaps afterwards we can talk offline and see if there's something that we as a firm can offer that would be a high level thing. But I think there was a question on like, what's your liability if you're giving legal or financial advice, and you know, it would be the unlikely risk, that relatively unlikely, but certainly possible, that you give a donor advice, they rely on it, or they think they heard X and it's really Y. And then it doesn't work out the way they want it. The funds don't go to the right place, and then their estate ends up in litigation, or they end up suing the chapter saying that you were doing the unauthorized practice of law. So we want to be really careful around those things. And so usually when we're preparing promotional materials for clients, you know, we're really careful about what we will say, what we won't say, what kind of disclaimers we have on those brochures, to ensure that we're protecting, both ensuring that we're giving accurate information, that we're not engaging in the unauthorized practice, that we're telling them that they need to meet with their own advisors and consider their own specific circumstances. Because often, I mean, what I found when I was working in estate planning is that sometimes the things that could cause the most problems for a client are the things that they don't want to tell other people. So they might have some family drama going on, they might have some debt going on, there might be things that they just don't want to say in a casual conversation, or in a conversation with a charity, that could have a dramatic impact on these things behind the scenes. And so really what we would view your role is educating them on the mission, educating them on the work that you're doing, and then encouraging them to, if it's going to be anything more complicated than a cash gift, or, you know, maybe a gift of securities, things like that don't have all of these restrictions, that they are engaging an attorney, so that someone that is not you is responsible for kind of delving into their private lives and making sure that the plan actually works. Because that's difficult enough for their attorney. And we certainly don't want you to put yourself in that situation.
Thank you. Andrea, did Brianna answer your question earlier about RMDs, or do you need that question to answer? I thought she mentioned that earlier, but I might have been mistaken. Is Andrea Martin still on? No.
I'll just do a quick hit on that. I mean, so each of the administrators for a retirement account will have a process where they can, the donor can do the qualified charitable distributions. Sometimes they get an actual checkbook where they can write out checks from their retirement account. Sometimes they direct the provider to cut the checks for them. So they'll want to work with whoever their their vendor is on the retirement account, but there is a way for them to have those go directly to charity without hitting their income tax, which is a huge benefit for those donors.
And another question, can we leave a Dollars for Scholars chapter in a trust, or does the donor have to go through Scholarship America? And again, I think you can, using the information that we can provide you, that to whom letter that just kind of shows the relationship between the chapter and Scholarship America, you would be able to leave that contribution to your Dollars for Scholars chapter.
Yeah. Often what they would do is, make sure that the attorney is drafting it so that that's all very clear in the provision.
Mm-hmm.
And so that's important. Nicole, I'm just going to kind of hit down through since I know we're running out of time.
Okay.
So with pursuing planned gifts, donors don't need to have an endowment fund. I would consider those two things to be separate. You can do a planned gift that's unrestricted. So I can have my retirement account go to the chapter with no restrictions. It could be used for the general operating fund. So it's still a planned gift, but there's no endowment fund required or endowment fund agreement. Really, the endowment comes if they're trying to kind of create a long-term scholarship fund, would be the most common, of course, for your donors. And so in that instance, it's really kind of talking through, are they able to commit at a level where they can actually meet the payout requirement, the payout to make the scholarship, right? And one of the things that I've seen is sometimes donors will combine.
Brianna, we've lost you again, and I know we're close to time, so there are several more questions there, and so I will relate these questions back to her. Actually, just I think 2 more questions. So we'll make sure that she answers those, and we will get the information back to you all. Again, we do apologize for the technical difficulties this evening. And we will just work to get you all the information that you need, okay? Thank you so much. You all have a great evening. And again, apologies for the technical difficulties. Thank you.